He'll either appeal this to the Supreme Court or he'll skip that entirely and go right to the Insurrection Act, which gives the president a lot more discretion and control, unreviewable discretion, than Statute 12406, which is what he used here. And the Insurrection Act bypasses posse comitatus, so it gives Trump even more authority as well. And now we're going to talk about the Seventh Circuit Court of Appeals handing a loss to President Trump. He had ordered the deployment of National Guard to Chicago. And of course, Chicago and the state of Illinois ran right to the unelected black-robe tyrannical inferior federal district trial courts, specifically the courtroom of Judge April Perry. April decided she knew more than the president, decided that the president was not privileged to deploy the National Guard if even once in a million times he was able to carry out federal law, because the relevant statute 12406 says the president can deploy the National Guard if he's unable to carry out federal law. And she said, well, he's not always unable to do it. If he's able to do it even once in a million tries, he's not unable, and therefore he fails that criteria for 12406. Of course, the proper measure would be if the president were unable even once in a million times, unable even once in a million times. And then she went on to say, when the statute says he's unable to enforce federal law with the regular forces, that doesn't mean ICE, DHS, FBI, Federal Protective Services. Those aren't the regular forces. Judge April Perry says the regular forces are the full-time U.S. military, Army, Air Force, Navy, Marines, Coast Guard, Space Force. Under 12406, by Judge April Perry's reading, Trump cannot be authorized to deploy the National Guard unless, first, he has deployed the full-time military and they have failed to be able to control Antifa. Can you imagine? So she ordered Trump, prohibited Trump from deploying the National Guard in Chicago. He appealed that to the Seventh Circuit Court of Appeals, and Trump got a rejection from the Seventh Circuit Court of Appeals. And by the way, all the left, of course, is crowing about this another court loss for Trump. And fair enough, you have to call this a court loss for Trump. But I would suggest that when Trump has had scores, 20-fold of these federal court losses, and yet he's 25-0 with the Supreme Court, that somebody is doing it wrong here, but it's not Trump. I would suggest it's these federal judges. He'll either appeal this to the Supreme Court or he'll skip that entirely and go right to the Insurrection Act, which gives the president a lot more discretion and control, unreviewable discretion, than Statute 12406, which is what he used here. And the Insurrection Act bypasses posse comitatus, so it gives Trump even more authority as well. On October 4th, Trump invoked his authority under 12406 to federalize and deploy members of the National Guard within Illinois over the objection of the state's governor. Trump asserted that deploying the Guard was necessary to quell violent assaults against federal immigration agents and property. The state of Illinois and the city of Chicago promptly sued President Trump and members of administration, arguing that none of the statutory predicates for federalizing the Guard under 12406 have been met. The unelected black-robe tyrannical inferior district trial court judge April Perry granted Chicago and Illinois' request for a TRO, enjoining the administration from federalizing and deploying the Guard within Illinois. Later, they changed that to just not being able to deploy. In the trial court's view of the factual record, neither of the predicate conditions for federalization offered by the administration was present in Illinois. So what federal judge April Perry said was, it's only a rebellion if the entirety of the U.S. government is being overthrown. It's not a rebellion if people are rebelling only against a slice of the government. This activation of the National Guard by the president has been used dozens of times in America's history. Never has it been required. Never has it been a case where the entirety of the federal government. For example, George Washington federalized the National Guard to stop the Whiskey Rebellion. That was not an attempt to overthrow the entirety of the federal government. That was merely a rebellion against a federal tax on whiskey. So this is obvious nonsense. Nor was there sufficient evidence that the president was unable with the regular forces to execute the laws of the United States. Again, according to Judge Perry, unable means he can never do it. If he's able to do it once in a million tries, then he's able to do it. So he would fail this test. And the regular forces, according to Judge Perry, means the active professional military. So he's not allowed to activate the National Guard unless first the Army, Navy, Air Force, Marines, Coast Guard, and Space Force have all collectively failed to execute the laws of the United States. Trump immediately appealed. Because we conclude that their factual findings were not clearly erroneous and that the facts do not justify the president's actions in Illinois under 12406, we deny the administration's motion for a stay, except to the extent we continue to allow federalization of the Guard, but not deployment of the Guard. We draw our account from the trial court's factual findings in its opinion granting the TRO. Now, this is just a kind of sleight of hand by this federal court of appeals. On the one hand, they're supposed to say that, well, we're not a trial court, we're an appellate court, and we don't want to do a trial court's job. And when a trial court makes a finding of fact, we're supposed to defer to that finding of fact, even if we disagree with it, even if we would have come to a different conclusion. We're supposed to defer to their finding of fact unless it's clearly erroneous. So this Court of Appeals is hiding behind that legal standard. Of course, the real problem with the trial court's ruling, temporary restraining order at all, is that the court imagines that it has the authority to second guess the president at all. Now, you might imagine a scenario in which there's nothing happening, literally nothing happening, to impair the president's ability to carry out federal law. But as other courts of appeals, like the Ninth Circuit Court of Appeal has said, and as the Supreme Court has said, if there's anything that the president could interpret as impairing his ability to carry out the laws, he can activate the National Guard, and that's non-reviewable. So this appellate court is applying exactly the wrong standard. They're saying, hey, the trial judge gets to make a call, and then we have to defer to her call. The correct answer is the trial judge does not get to second guess the president's assessment of actual facts on the ground. The president's not fabricating that there's violence against ICE for the purpose of impeding immigration laws. That's clearly happening. Even this court had to say in its introduction that there is the Guard was called up to quell violent assaults against ICE agents and property. This is really happening. It's not a figment of Trump's imagination. And if it's really happening, only the president gets to determine how serious it is and whether or not the National Guard should be called out. But of course, they want to rule against Trump. So they're pretending that this is like a litigation between regular parties, like two plaintiffs before them. If there's two plaintiffs asking for a TRO and the trial judge makes a factual finding, yes, the Court of Appeals is supposed to defer to that factual finding. That completely misses the point here, that what's at stake is the exercise by the Article 2 executive branch president of his core and plenary powers as commander-in-chief. Completely changes all the metrics of evaluating what a federal judge is allowed to do. But anyway, the Court of Appeals continues. We draw our account. We just adopt the trial court's factual findings in the TRO. On September 8th, Trump announced Operation Midway Blitz, an escalation of immigration enforcement in Illinois. Federal law enforcement officers increased their presence in the Chicagoland area. ICE processes immigrant detainees at a facility in Broadview, Illinois, about 12 miles west of downtown Chicago. For the past 19 years, protesters have engaged in small demonstrations outside Broadview, including a weekly prayer vigil, but the protests grew in size. Anyone ever heard of protests outside of Broadview happening for 19 years? What nonsense. But the protests grew in size and regularity following commencement of Operation Midway Blitz. On some occasions, protesters have stood or sat down in the driveway leading to the Broadview facility. This is called impeding federal law enforcement. It's a federal felony. And ICE has physically removed those people. The number of protesters on a typical day is fewer than 15, but sometimes it's in the hundreds. So what's supposed to happen? Trump can call out the National Guard within the hundreds, but if the next day there's only 50, he's got to send the National Guard back home? It's insane that federal judges believe they get to make these kinds of on-the-ground calls. The Broadview Police and the Illinois State Police have set up surveillance cameras to record and monitor activities. September 26th, 100 to 150 protesters gathered, and ICE deployed pepper spray and tear gas. Anyone think ICE deployed pepper spray and tear gas just because protesters gathered? Is that what you think happened? Isn't it weird how this Federal Court of Appeals leaves out the fact that ICE would have deployed pepper spray and tear gas only if things had gotten violent? The Broadview Police Department requested assistance from Illinois law enforcement, and state police and other local police departments sent 6 cars for 150 people. The activity near the facility closed a nearby road for 5 hours, but Illinois law enforcement was able to contain the scene. But whether they were able to contain the scene is not the legal question here. The question is, was Trump unable to carry out federal law? The scene can be contained, and he's still unable to carry out federal law. That same day, DHS requested from the Department of Defense 100 troops to protect ICE facilities and personnel with immediate and sustained assistance because of a coordinated assault by unnamed violent groups. Do the groups have to be named? Do they have to have a brand and a trademark before they're violent and the National Guard can be called out? Of course not. Unnamed violent groups actively aligned and designated with domestic terror organizations, including, of course, Antifa. Operation Midway Blitz soon intensified. On September 27th, Gregory Bavino of Customs and Border Protection and other federal agents came to Broadview Police Station, said that there would be increased deployment of chemical arms and that it was going to be a shit show. Why were they saying that? Because Broadview police were not controlling the violence of the crowds. The same day, a federal officer requested that Illinois voluntarily send the Illinois National Guard. The state declined. In turn, Illinois law enforcement stepped up its efforts in Broadview. But did it, though? On October 2nd, Illinois State Police created a unified command of state and local enforcement and emergency response organizations. But did any of this suddenly enable Trump to carry out federal law? That's the only legal question under 12406. On October 3rd, so one day, when some protesters attempted to approach federal personnel and property, state and local law enforcement maintained control, making 5 to 7 arrests, and federal agents detained 12 people. But what's maintained control mean? Does that mean the feds were able to carry out federal law? Or does that mean they simply stopped the violence? Because nonviolent impediment of federal law enforcement is still impediment of federal law enforcement. On October 4th, a few dozen protesters demonstrated. State and local officials quickly responded and controlled the scene. DHS did not have to intervene, but were they able to carry out federal law? That same day, October 4th, the president invoked his authority to federalize the National Guard, issued a memorandum stating the situation in the state of Illinois around Chicago cannot continue. Federal facilities supporting ICE and FPS have come under coordinated assault by violent groups. I've determined that these incidents, as well as the credible threat of continued violence, impede the execution of the laws of the United States. I further determined that the regular forces of the United States, by which he means ICE and FSP, are not sufficient to ensure the laws of the United States are faithfully executed. The memo authorized the federalization of the Illinois National Guard under 12406 to perform those protective activities the Secretary of War determines are reasonably necessary to ensure the execution of federal law in Illinois. So not law enforcement activities, protective activities, protective of federal property and personnel. Illinois state officials opposed the deployment of the National Guard. The National Guard Bureau notified the Adjutant General of the Illinois National Guard. The president planned to deploy at least 300 members of the Illinois National Guard within 2 hours. Or the secretary, asked them to do it, or the Secretary of Defense would do it himself. The Adjutant General said Illinois Governor Pritzker would not call out the National Guard. So Pete Hegseth, Secretary of Department of War, called out the National Guard under 10 U.S.C. 12406. to protect, enforce federal law, protect federal property at all locations where violent demonstrations were occurring. The next day, Secretary Hegseth explained to the Adjutant General that the president was invoking 12406 to federalize an additional 400 National Guard from Texas and to deploy them, those Texas Guard, in Illinois and Oregon because of violent incidents as well as credible threats of continued violence, impeding the execution of the laws of the United States. There were also a few dozen protesters at the ICE facility in Broadview that day, but state and local enforcement maintained control and DHS did not intervene. Despite President Trump's federalization of the Guard, DHS and ICE have touted the success of Operation Midway Blitz. So again, unless Operation Midway Blitz was utterly lacking in success, Trump has no right to call out the National Guard, according to these judges. They get to determine how much success is enough. So if Trump says, hey, good news, we got rid of 1,000 illegal migrants, we could have gotten rid of 10,000, but for these unlawful violent protests, but we got rid of 1,000. That's not bad. These judges would say, well, he's touting the success of the operation. He can't possibly need to call out the National Guard. In fact, that's what they said. ICE and CBP said they got rid of more than 1,000, made 1,000 immigration arrests. The department declared the protests had not slowed ICE down, and in fact, ICE had significantly increased its deportation and arrest numbers year over year. So again, these are these unelected black-robe tyrannical inferior district trial court judges. They get to decide, or these are Court of Appeals judges, they get to decide whether or not they're satisfied with the progress of the operation, whether or not the president's making the judgment call, gets to make the judgment call on whether he needs National Guard to execute federal law. On October 6th, the state of Illinois and Chicago filed this lawsuit. 12406 says, when the United States is invaded, 3 clauses under 12406 to activate the federal National Guard, or the National Guard, I should say. The first deals with foreign invasion. We're not talking about that. Trump can call out the National Guard when there's rebellion or danger of rebellion. These judges say that only applies to rebellion threatening the entirety of the federal government. Not even the Civil War threatened the entirety of the federal government. The Confederate States were not trying to take over the northern states, the U.S. federal government. They were just trying to get their independence. The Whiskey Rebellion did not threaten the entirety of the United States. School desegregation did not threaten the entirety of the United States. But in those cases, calling out the National Guard was fine. So this argument these courts keep making that it's only rebellion if the entirety of the United States is about to be overthrown is obvious nonsense. And then Section 3, if the president's unable with the regular forces to execute the laws. Again, they say unable means if he tries 1,000,000 times and he's able to do it once, that means he's able and he fails this test. And the regular forces mean the full-time professional military. Trump's not allowed to call out the National Guard unless he first tries to suppress the violence with the Army, Air Force, Navy, Marines, Coast Guard, and Space Force, and they all fail. If they all fail, the full-time professional military fails, then Trump is allowed to call out the National Guard. Chicago and Illinois argue there is no rebellion or danger of rebellion, nor is the president unable with the regular forces to execute the laws of the United States. After holding a hearing and assessing the preliminary record, the trial court granted the TRO, enjoining both the federalization and deployment of the National Guard for 14 days. Then this Court of Appeals did stay the federalization part. So Trump is allowed to federalize the National Guard, but they did not stay the deployment part. So Trump was still not allowed to deploy. He could activate the National Guard, but he was not able to use them. That makes a lot of sense, right? We conclude that this TRO is appealable. The district court issued a thorough 51-page written opinion after holding an adversary hearing and receiving extensive factual submissions and briefing. The administration has strongly challenged virtually every basis for the district court's order. So we're satisfied we should treat this as a preliminary injunction, which is appealable. Let's see. In deciding whether to pause an injunction, we apply a standard that parallels the preliminary injunction standard, but also keeps in mind the district court's exercise of equitable discretion. We should defer to the district court on fact finding. The party seeking a stay has to show, this would be Trump, a likelihood of success on the merits, This is really the only one that matters. So this is the only one I'm going to cover. Trump argues the president's federalization of the Guard under 1246 is not judicially reviewable at all. It contends that the factual predicates of 12406 2 and 3, rebellion and unable to enforce the law with the regular forces, are satisfied in light of the deference due the president's decision to federalize the Guard. We conclude at this preliminary stage, and given the district court's factual findings, that the federal government does not appear likely to succeed on either argument. The administration principally asserts that the president's discretion to call up the National Guard simply is not judicially reviewable. The argument relies heavily on Martin v. Mott. President Madison had invoked a precursor of 12406 to mobilize the New York militia during the War of 1812, which President Madison deemed to be an invasion. A militiaman, Jacob Mott, refused to report for duty. He said, I get to make a judgment call, or at least I can ask a federal judge to second guess the president on whether the National Guard can be activated. The Supreme Court concluded that the determination whether an actual invasion has arisen was not an open question upon which every officer may decide for himself, but belongs exclusively to the president, and that his decision is conclusive upon all other persons. Well, pretty comprehensive. That's the Supreme Court of the United States. The administration argues that those principles govern here, and that whereas here a statute commits a decision to the discretion of the president's exercise of that discretion is not subject to judicial review. We, the Seventh Circuit Court of Appeals, do not think the holding of Martin can extend so far. The Supreme Court's broad language must be understood in its context. The nation was then at war with the most powerful empire on earth. That empire had actually invaded the United States and was sacking its capital city in 1814. You see what the Seventh Circuit Court of Appeals is doing here? They're saying, we don't like the president's decision-making. We think he didn't consider these other factors. We consider these other factors. We give them the weight we decide to give them. And if our conclusion differs from the president, the commander-in-chief, the Article 2 executive branch president, elected by the whole of the American people to carry out our political will, if the judgment of us unelected, black-robe, tyrannical, inferior federal judges disagrees with the president, commander-in-chief, we get to make the call and veto his activation of the National Guard. That's what they're doing here by raising all these other factors as if the president had not considered them or was obliged to consider them.